Good morning, afternoon, evening. Hello there, Toe Cramp. I think you're the only one there right now, but thank you. Thank you for joining. Whenever somebody watches this, whatever, whenever, thank you. Hello. What I wanted to do was to talk about the ruling on the Trump tariffs that was undertaken by the Court of International Trade yesterday, kind of what impacts it might have. I'm just speculating, and I'm going to kind of go against the trend. So the after the decision came out yesterday, the markets kind of beefed up. I think it creates more uncertainty than certainty. That's just my view. But we'll kind of go through. We will kind of go through what's going on. Just again, saying hello to Toe Cramp, the one, Chad, and there's the gentleman who is always here, never fails to be here, Mr. StreamYard. So hello, Mr. StreamYard, also for joining us today. So anyway, I wanted to talk about the decision before, of course, I get into the decision. I wanted to briefly reference a couple of things. And hello again, not legal advice. Please like, subscribe, share, comment, whatever, all that nonsense. And hopefully this will explain or put it in more context, because when not everybody heard this yesterday, it sounded like the tariffs were dead. That was kind of the conclusion. I think that's probably a very big oversimplification, and we will go from there. So I wanted to run three things quickly by you. Did you hear about the lawyer who sued the funeral company over a coffin? It was an open and shut case. It was an open and shut case. It was an open and shut case. What do you call a priest who becomes a lawyer? A father-in-law. And last but not least, or least but not last, what's the difference between a lawyer and a vulture? The lawyer gets frequent flyer miles. Anyway, hopefully you enjoyed those wonderful jokes. And so let's talk about the ruling yesterday. So it involved something called the Court of International Trade, which is a court that's a specific federal court designed to handle matters related to trade, international trade, etc. It's an Article 3 court, which means that the judges are appointed for life, like any other federal district court, and they have the same privileges, etc., as other federal judge. Those are called Article 3 judges, just for the sake of discussion. Article 3 referring to the Constitution. Now, a lot of people get upset when rulings don't go the way they go, and they attribute the rulings to bias, etc. Sometimes that could be true. Not going to say it's not true. But in this particular case, there was the three-judge panel, and of the three judges, one was appointed by Trump, one was appointed by Reagan, and one was appointed by Obama. So three judges, two appointed by Republican presidents, and the decision was unanimous. So tough to say that this was a biased decision. May have been incorrect, may have been overbroad, but hard to say it's biased if there's a unanimous decision and two of the judges were appointed by Republican presidents. So that's kind of my view on it. So what did they rule? So the issue that came up was whether the president, when he did Liberation Day, whatever that day that was called Liberation Day, and that day imposed across-the-board tariffs 10%, on some countries, reciprocal tariffs that were higher than that. He had imposed tariffs on Canada, Mexico, and China. So there was a lawsuit or lawsuits that were filed by small businesses and by states, two separate things. And they filed the lawsuits in the Court of International Trade. I think the original lawsuit by the states was filed by Oregon and joined by several other states. As to the business side, about a month ago, I did maybe more than a month ago, I did a video, I think, about a gentleman by the name of Leonard Leo, who was involved in an organization that had filed a lawsuit in Florida about a small stationery company in Florida, and they had to import products from or at least materials from China, and basically destroyed their business. They filed an action. I think, in essence, that kind of action is what got rolled into this also. What was unusual that I pointed out at that time, the gentleman's name was Leonard Leo. He happened to be an advisor, a Supreme Court advisor to President Trump during the first term, and he is given the I guess the benefit of having organized the conservative court. So he arranged, or he's given credit for getting Gorsuch, Barrett, and Kavanaugh into the Supreme Court to give it a right direction, R-I-G-H-T, as opposed to correct. I meant conservative direction. And he's responsible for that. Except on the tariff issue, he took a stance directly opposite to the White House. So that's interesting. I pointed it out at the time. Now, since this ruling, I think it's more appropriate. It's interesting that somebody who was a close advisor to the president and who was involved with the Supreme Court was the one who's now opposing tariffs. Anyway, just found that was an interesting point. Now, this decision doesn't apply to all tariffs. It only applies to tariffs that were brought under a specific act. And that act, as we all know, of course, is called the International Emergency Economic Powers Act of 1997, or as we all like to call it when we're talking over coffee, the IEEPA. And that basically gave the president, or the executive branch, it's from 1997, gave the executive branch the power to impose necessary economic sanctions to combat unusual and extraordinary threats. And so he can, in essence, can somehow regulate foreign international commerce through this. Now, this particular act, the IEEPA, was never used prior to now to justify the imposition of tariffs. So this is what would you call be a case of first impression. In 2019, I think there was a threat by the president at that time to use it to impose sanctions on Mexico, but it never ended up being used. So it's never been tested. But all the sanctions that were imposed on Liberation Day and against Canada, Mexico, and China, I think incorporated these, or most of them were incorporated. Now, the IEPA doesn't deal with all products. It has a lot of exemptions. And so steel, aluminum, autos, pharma, semiconductors, and a bunch of other things are exempted for this. So the decision yesterday wouldn't cover those items, although they can be covered in the process. So what happened is the court heard these arguments and decided that the imposition of the tariffs across the board was not what was contemplated by this act. And so the White House said the basic reasons for the imposition of the tariffs was because of the trade issue and because of the drug cartels. But the imposition of the tariffs was across the board, irrespective of trade position. And the court deemed that the sanctions as to the drug cartels weren't targeted. For example, I don't know if it's mentioned in the opinion, but I remember like Canada was targeted the same as Mexico, but the fentanyl was not coming in through the same means through both countries, or couldn't be documented to be the same. I think the White House said it wasn't even the same, that Canada was at a much less stake. But anyway, there was across-the-board tariffs that were imposed against all countries. The court said you can't do that under this particular statute. It doesn't permit you to do that. And again, it permitted sanctions to combat the statute, so you could read it. It permits sanctions to be imposed to combat unusual and extraordinary threats. Again, never been adjudicated in a court or a higher court. So this court deemed that that statute's not fit for the use that it was used. It issued its ruling yesterday. That ruling has stayed for 10 days. It's in a federal court. That ruling could be appealed to the Court of Appeals for the federal district, which handles this particular court, or they could try a direct run to the Supreme Court. Now, the Supreme Court probably wouldn't hear it right now. They'd probably want you to go through the Court of Appeals, but the White House could also seek an expedited hearing, could seek a stay of the injunction. That's what was granted by the Court of International Trade. Basically, it entered an injunction barring all these tariffs being enforced. That's kind of the ruling. So you could seek a stay at the Court of Appeal. You could seek a stay from the Supreme Court. You could seek intervention by the Supreme Court. You could seek intervention by the Court of Appeal for the Federal District Court. That would be the most direct way of going, and the easiest probably to justify. And you could seek a stay of all this. A stay means they can't take action. And there's 10 days until this order goes into effect. So all this could be undertaken, all these requests could be undertaken in that 10-day period of time. Notwithstanding, and the reason why they ruled as they did, and they didn't say specifically why they did, but they kind of threw out three things. First of all, you should know that taxing and tariff authority belongs to Congress, not to the executive branch. So in order for that to be done, there has to be some kind of delegation of authority through some legislation, et cetera, like it was here. But it has to be very specific, and you can't have like an overbroad delegation. So there's three doctrines that they kind of reference as possible constitutional arguments that would prohibit this from being used to impose across-the-board sanctions. The non-delegation doctrine, which means that Congress can't just willy-nilly delegate responsibilities without being very specific in terms of its delegation and then supervising the delegation. And it probably didn't do that. The greater questions doctrine, which basically says, if it's something affecting interstate commerce and involves delegation to an agency, there has to be, again, very close supervision and clear delegation. And then there's a separation of powers issue that means that certain branches are responsible for certain actions, and here it's Congress and not the executive branch that has the taxing authority. And again, you'd closely scrutinize what went on. So the court kind of threw those out as possibilities. I've kind of thrown it out because it's been used by the Supreme Court in limiting regulatory power. So these are common theories that are currently being addressed by the court. So I expect an appeal. I don't think that this particular statute, this is my opinion for whatever it's worth, I don't think this statute is designed for the purpose that it's being used. And it wouldn't surprise me if the Supreme Court, if it got to that point, upheld the denial of those tariffs. But there are other means for imposing tariffs. So, for example, there are certain sections on those trade agreements, and there's an administrative process whereby you have to do it, but you can impose certain sanctions across the board at 15% for 150 days, I believe. So that could be done by the executive branch. You can impose sanctions per two trade sections. One's trade section 338, which says that for an unspecified period of time, so unlimited period of time, the president could impose a 50% tariff if a country discriminates against U.S. products and blocks imports. So that's interesting because that could imply that could be China, could be the EU, could be a lot of countries that block, in essence, imports. And so the president could impose 50% tariffs through that. Then through another act, Section 122, the 50% tariffs for 150 days could be imposed. And there's other sections if they want to do a dance and use tariff statutes to impose tariffs, they can. They could also impose statutes specifically related to countries, and they can undertake an investigation and find out if a country is involved in unfairly blocking trade. I know there's an investigation on in China as to, I think, semiconductors, et cetera. And through that, you can impose basically country-specific sanctions. You could also find certain products, like, for example, I said autos were omitted or whatever. You could limit sanctions and specify sanctions to certain product groups. So all those are still on the table. The reason why I think they chose the IEPA was because that was the quickest way of imposing sanctions, because they didn't have to ask for anybody. They didn't have to do an investigation, didn't have to have any findings. So I think that it doesn't forbid further tariffs for being imposed. It just makes it slower process. And I think what the practical effect is that in these trade negotiations now, somebody could take the position, so the leverage of the White House is gone. I think the flip side is in trade negotiations now, they could say is, okay, the court's challenging, we're challenging it. We don't know how it's going to go. But if they don't go our way, we're just going to impose sanctions using a different statute. So either way, you're going to be subject to it. So you can agree now or you could agree later. So I don't think it stops the executive branch from imposing sanctions. I just think it delays the imposition, creates a little more uncertainty, because in these trade meetings, whereas in the past they may have had just one particular statute to deal with, now there might be multiple statutes, and some countries might think they have leverage when they don't. So I think that might complicated the certainty of the tariff issue. I know in some parts I saw yesterday, and the market reacted that way, that this created certainty. I think it does not. I think it kind of creates more potential issues. The president can certainly cite one of these new statutes and say if he doesn't reach a deal with the EU, and maybe that's where it came from, by the way. I think that's interesting. Hadn't thought about that. Before there was an agreement, I think, to extend the EU tariffs, there was the president said he was going to raise it to 50%. That might be correlated to that Section 338, where there's a complete kind of, in essence, blockade of American products. I know, like cars, for example, into Europe, American cars, you can't go there. So maybe that's where it comes from. So I don't think, again, the decision that came down, it certainly does put the stop, slows it down, but it doesn't eliminate the tariff issue. It just adds new wrinkles to it. And I think it's just going to be another thing that's going to be negotiated in these trade deals. And there'll be more potential options that could be exercised imposing trade tariffs. Again, I agree with the court. I don't think this statute, the IEPA itself, was designed for the purpose intended, but from a practical standpoint, I understand why it was used, again, because it provided the fastest way for the executive branch to impose tariffs. So just to recap, I think the court's decision is correct. I think there'll be an appeal. I think it'll go up probably both to the Court of Appeals, and they'll give a stab at the U.S. Supreme Court. I don't think this particular statute is really intended as across the board, all countries to impose tariffs, but I see that there's other sections that could be used, especially against China and other trade, and probably the EU, against other trading partners that could provide the same type of restraint. The court was mixed, 2 Republican, 1 Democrat. There are other statutes that can be used by the executive branch to impose the tariffs. I think they will be used. I think they will certainly be threatened. I don't think this creates less uncertainty. I think it creates more uncertainty. But I think ultimately all this tariff stuff will wash out and there'll be some agreement. It's really an issue of trade, not tariffs. I think that was the confusion it presented, that it was an issue of tariffs, but this really is an issue of an imbalance in trade. And I think based upon the statutes that are available, that those can be serviced. Now, again, the thing that struck me when I did this video about a month ago, live stream about a month ago, when I was talking about Leonard Leo, was the fact that he was opposed to the administration's use of this section to impose tariffs. And I think, and he was the one who was responsible for getting a conservative court established during the first Trump administration. So I found that that battle interesting, and it seems like the Leonard Leo side prevailed, at least when it came to the IEPA and the imposition of tariffs. So to summarize, court ruled there can be an appeal. I think that I think as to this particular statute, the executive branch may lose, but tariffs can be imposed in alternative ways. I think they will still be discussed in trade negotiations, and I think the tariff issues eventually will be resolved. And I don't think this ruling by the Court of International Trade, fully resolves the issue of tariffs. I think people got the idea it did. And that's notwithstanding the number of items, like as we discussed, aluminum, autos, semiconductors, steel, pharma, that are currently excluded, that the president could target separately as a class of goods, or could target a country, as I indicated, using all the other statutes. So that's an explanation. So I don't think it's the death knell to tariffs that was mentioned or kind of discussed yesterday. And I don't think it was the certainty that everybody was talking about yesterday either. I think it was a ruling on a statute, one singular statute, and there's other ways around it, and it doesn't conclude the topic. Anyway, hope that provides some clarity. If you have questions, comments afterwards, please put them somewhere. But that'll kind of hopefully describe for you where we are, what will happen. We'll know better in 10 days when the period of time to appeal runs, and we'll see what the White House does. I'm sure that's going to be appealed, but I would expect in the meantime, as I indicated, they'll probably seek a stay of enforcement of the injunction. That's what I would expect them to do. We'll see. We'll see, and I'll report on it over the next 10 days. Thanks for watching. Hope this was helpful. Hope it explained at least a little bit about what's going on. Since it's never been challenged, it's a novel section. We'll have to see how the courts look at it. But that's it. So everybody be well. Have a great day. Take care.